Hey, Kevin. Here we are in a weekend edition of the Readathon.
Hello, Rebecca.
And it's a few things I wanted to go over with you.
Mm-hmm.
Okay. So the other day, at the beginning of the weekend, I put up a post, a text-only post about some of the social media goings-on in this case. And one of the things that happened that struck me as a little bit funny, and I would suggest people go read it because I talked a little bit about some of the sock puppet accounts on Twitter and posted some examples of some of those. But one of the things that I posted about that I thought was kind of funny and weird was that there is this woman, this content creator. Her name on TikTok, I believe, is Nerdy Pink Panda, but she goes by @SherryTeal14 on Twitter, SherryThiel 14 on Twitter. Okay. So she posts videos about all kinds of true crime stuff, and she's been posting about the Karen Read case. And apparently, one of the things she posted was her belief that the Albert's Pizza Shop is covering up for like drug sales operation.
Okay.
Which, by the way, I'm not saying that it is a drug sales operation, but I'm just going to say that's not the first time I've heard that stupid rumor.
Okay.
But yeah, it is a rumor that people say. But so that's one of the things I guess that she said on her TikTok, and she's very funny and cheeky or whatever. So she was sent a fake cease and desist letter. By D&E Pizza, by the Alberts, basically.
Y'all, I am scaring them. I was done for the day, and then I got this fake cease and desist letter on behalf of their client, D&E Pizza. But you want to know how I know this is a fake cease and desist? Because this is where I keep my real ones, proudly on display in my room. Let's compare, shall we? Here we have an official letterhead. Here it just says, State of Massachusetts. Here they decided desist was going to be the only word that they didn't capitalize in this sentence. Slander and libel are two different things. It can't be both. They tell me the exact price, $50,000, that they would sue me for, and also say that I have to make an online apology. Notice how a real cease and desist specifies exactly what I did wrong, or what they claim I did wrong. And this just says many social media videos. That's not how it works. Oh, and here they said that they would file in Superior Court without further reference to you. No, you have to serve me. You don't get to not inform the person that you're suing, that you're suing them.
This fake letter was easily debunked because the lawyer who sent it does not exist. All right?
Shocking.
Yeah, she was very easily able to suss that out.
Oh, but this is my favorite part. Notice how a real lawyer actually signs their stuff, as well as includes, like, an address and a phone number. While this one's just signed Samson Benavidez with an email address, Massachusetts Civil Attorney. Here's the thing. Lawyers don't generally tend to have Gmail as their email. When I do a background check on that email address, there's absolutely no information. You'd think an email for a lawyer would show up on a background check. In fact, Samson Benavidez doesn't show up anywhere, Googling nothing. You think a lawyer would at least have one Google search hit.
She posted a follow-up to this TikTok. Yeah. And as somebody on Twitter pointed out after this, these two names, Samson Benavidez, it is the name of a boxer and his manager mashed up together.
Okay.
And a very, I guess, well-known boxer and his manager. And I guess, it doesn't take a genius to realize if you want to look for boxing fans in this case.
Yeah. It'd be like Paul Lennon and John McCartney.
It would be like
something.
Yeah, it would be like having.
But yeah.
Muhammad Tyson would be like the
Okay. Yeah, sure.
If you're going to have if you're going to draw strings here and say like who in the Read case are boxing fans.
Yeah. Maybe not everybody would get it, but it's kind of if you know, you know.
Right.
Okay.
And there are boxing fans in the Albert family. We know that.
There are,
okay.
Fans? Yeah, exactly. Okay.
So the other thing that she said was that she reported them, she responded to the Gmail address and she reported them to the FBI because it turns out impersonating a lawyer is a crime. So
okay.
I looked that up.
All right.
I wanted to tell you what it is or isn't a crime, okay? So it turns out impersonating a lawyer specifically is not a crime specifically in every state.
Okay.
But it is a crime in every state to hold oneself out as a professional and reap the benefits of that when they are not entitled.
Yes, yeah. Which doesn't mean like you cannot represent yourself pro se and act, quote, as a lawyer,
Correct.
lowercase l.
Correct.
But right. And
there's more.
Yes, okay.
Even when there is no specific statute for impersonation, and Massachusetts does not cover lawyers, it does deal with public officials, though. Like if you impersonate a justice of a peace, you can be fined, etc.
Yeah.
It is still prosecutable as fraud. Now, if it's prosecutable as fraud, it could fall under the identity fraud statute. The identity fraud statute in Massachusetts is punishable with imprisonment for up to 2.5 years and a fine up to $5,000 and restitution of any financial loss. So, in order to be convicted of a crime of identity fraud, the prosecution would be required to prove that the defendant has posed as another person, and if it's another specific person, that the defendant did so without that person's authorization, that the defendant used a person's identifying information to obtain or to obtain money, credit, or some other thing of value, that the defendant did so with the intent to defraud, and for the purposes of the crime of identity fraud, to pose as another person to falsely represent oneself directly or indirectly as another person. So you could say, because they said they were going to sue her for 50 grand, you could say potentially this is covered there. I don't know. But anyway, I did look it up. Posing as a lawyer specifically in Massachusetts is not a crime, but it could be a fraud. Okay. So that was one thing I wanted to talk about. And I just think the fake cease and desist letter thing is so fucking funny. It is. It's funny.
You know,
because listen, if
at least she pulls it apart about the things that they did wrong.
Yeah.
But also, and I think we mentioned this at breakfast today, that what they could have just done, if there is an issue, because I think when we talk about exactly sort of like what precipitated this and what the cease and disorder is asking, the fake one, what is trying to achieve.
It's to get her to stop talking about their pizza shop as a drug operation.
Right. Yeah. And whether or not what she says is protected or it's across the line, whatever, they could just get a real lawyer
to send a fucking letter
and pay the real lawyer $100, $200 an hour, whatever it is.
Correct.
Form letter, send it off.
Right.
Certified, whatever.
Or they could just send the letter themselves.
Send it themselves.
With their own signatures and say, we're going to take legal action if you don't stop. You can send your own cease and desist.
Send your own letter.
So this is the whole thing. It's like, and you don't have to.
By the way, it depends. Maybe they don't know mailing address for
they sent
so-and-so.
It to her?
Was it an email?
It may have been an email, but she's received them before. She said, but they sent it as an attachment.
Oh, okay. Yeah,
so she said she's received gotten other ones, and she keeps them up on her bulletin board. But the whole thing about a cease and desist is it's not a lawsuit. So you're not opening yourself up to being deposed if you send a cease and desist. You can send a cease and desist, and that can just be scary enough to stop people.
Yeah.
But the fact
you can continue to do whatever. It's not a legal document.
It's so bush league. It's just so fucking bush league and amateur, which goes along the theme of some of the social media stuff I talked about in my blog post this weekend. It's bush league. It is bush league to pretend to be other people on social media and pretend that you're someone neutral when you are obviously somebody involved in the case. It is fucking bush league. All right, so another thing we have to talk about. The DA has filed their response to the defense's motions to dismiss and all the affidavits filed by Alan Jackson and David Yannetti.
Okay.
We now have 4 jurors who have ostensibly come forward or spoken to others who have then come forward, causing Jackson and Yannetti to file affidavits to support their motion to dismiss. Of course, all these sum up to that Reed should have been acquitted on 2 of the charges that she was accused of, the most serious offense and the least serious offense, because the jury were not asked by Judge Bev Cannoni which charges they were hung on before she declared the mistrial. That's the premise, right?
Yeah.
DA Morrissey, via Lally, who wrote the motion, saying, against, the filing against the dismissal, says essentially 3 things, and I'm just going to sum them up. There's lots of case law saying that the foreperson himself has to say not guilty on each charge out loud in the courtroom.
Okay.
Now, one could say, for instance, that he was not given the opportunity to do so. He or she was not, right? Number 2, the defense could have objected to the mistrial or could have said something in the moment, basically, and did not. Okay?
Okay. Yeah. I mean, that's not how it played out, but yeah.
It's not how it played out at all.
Yeah, right.
And number 3, that the defense's communications with the jurors are improper. They're only allowed to talk about jurors in a case at this point about their performance in the courtroom, etc. I think that's probably true if they had reached out to the jurors, but that's not the case here, right?
Right. Yeah.
And what's interesting to me is that we don't know if these jurors also reached out to the prosecution side. I would not be surprised to hear that they had.
Yeah. But I mean, if I were to reach out to one, I would definitely reach out to the defense because this is who
I'd
this
reach
concerns.
out to both.
Yeah, both. Yeah.
Anyway, so that's something else I wanted to talk about.
That's interesting. I found because I have read, or was someone read to me, like while I was driving, like yourself, the filings on both sides, and both are really strong arguments. Actually, I mean, they're both well reasoned and whatnot. What I'm thinking here is that, and one of the, I'm just going to really summarize it. One of the prosecution's arguments is that unless it says it out loud in public, it doesn't count, right? So if it was never declared or whatever like that, it's oopsie, right? I feel like that this becomes immediately an appealable issue for the defense. Now, usually when you have a reversible error, what that means is you can only really pursue that after the trial. So if she were convicted and there was something that happened, like, the judge made a mistake on this, and then we know this. We see this is how it plays out. It plays out after a conviction and things start to roll, and they roll slowly. But there are exceptions where an appeals court would hear something before trial, before a second trial, and those have to do with, and we've learned this in the past year, have to do with instances of immunity or double jeopardy. Essentially things that say you shouldn't be put on trial in the first place.
Right. So
I think that they've got at least an argument here for, appealable argument saying this is double jeopardy. The judge never asked if she had, her constitutional rights would have been affirmed, et cetera, et cetera.
Right.
I think they can make the argument and certainly push this off.
The only way to do it, though, is to bring all the jurors back. It's the only way to do it.
Yeah, and apparently, if the jurors are right, they're all going to attest to that's where we were.
Yeah.
And they probably was, where they were deadlocked was on this other second issue. I'd love to ask them too about, was that jury slip confusing to you? Because that was also an issue.
I think it was an issue.
Yeah. Anyway.
There's one other thing about the trial.
Really fascinating. Yeah.
There's two things about the trial. Actually, there's one thing that's sort of an overarching issue, but there's two things about the trial specifically that I want to mention about the case and the trial. One thing that you and I have talked about, and I tweeted about it a few weeks ago, is... there are a lot of things in this trial that just get said and then they become lore in the case and then they're believed to be true. One of them was pre-trial. It came up in early reporting in the case that when Karen Read was arrested, somebody told reporters that there was Ring camera footage from across the street of her having hit John O'Keefe.
Sure.
It shows up prominently in a WBZ Boston story. That story is still on the website. They have issued a correction on top of the story saying that they've reworded that paragraph. It used to say, the police have Ring camera footage of that night. Now it says, I-Team sources say the police have Ring camera footage of the night, and they are ascribing that change to a transcription error, which I have questions about. But
I thought it was actually more explicit, where they said they originally said there is video,
Ring camera footage of
and
it.
Now they've attributed, basically couching it saying, law enforcement officials say.
No, I-Team source says.
Said, right. They've attributed it. They didn't play it out as fact. Because one has to wonder, where is that video?
Where's that story?
Because if that video existed, it is clear and convincing evidence of what the crime was.
Correct.
Why wouldn't that have been presented?
Well,
and then it leads to the question of, well, then why was that statement made?
I know.
Rebecca?
I can tell you what I think.
Tell me.
I think the police lied about the existence of that video.
I agree.
I think the police they leaked to the media the existence of the video. Whatever reporter picked it up, ran with it and said, there's video of her doing it. I'm not 100% sure they didn't say it on the air, because the video story they have attached to that web story is not the video story in which they mentioned
that fact kind of lived in the ether for a long time. I think they were waiting for that at trial, right?
People still think that video exists. Anti-Karen Read people still think that video exists. Okay.
Yeah. Because there was talk about there's a Ring camera across the street.
Right.
What happened to that camera?
It's not missing footage. I don't think it ever existed.
Yeah.
So here's what I think.
Yeah, go ahead.
So there's a situation. There's one situation that I don't know if all listeners understand, which is that at her original arraignment, Karen Read's lawyer, Yannetti, said she's being overcharged. This was just a terrible accident, right? So Karen Read I briefly believed she may have hit him, right? Mm-hmm. And I don't think she said, did I hit him that morning of the crime? I really don't. I'll explain why if you want to hear it. But I don't believe she actually said that, which I think I talked about in the when we talked about the microdots video. I believe that came from Jen McCabe and then became lore as well. But so she, I think, was told when she was arrested, and or she saw on the news when she was arrested, that there is ring camera video of her hitting John O'Keefe.
Right.
So if she's drunk, or if she knew she was drunk and she's unsure, and then she hears, oh, there's ring camera footage, you know, why wouldn't she believe that she was arrested for, like, that there's evidence, right? Why wouldn't she believe it? This happens all the time. That happens. We watched that thing about rape victims, right? Mm-hmm. Where rape victims are told that there's video evidence that they weren't raped, and so they recant the rape accusation, and then they get charged for making false allegations. This happens where witnesses are told and suspects are told all the time that there's video of them committing the crime when there isn't. Police are allowed to lie to suspects. Yeah. And I believe that lie was leaked to the media, and that's why the media ran with it, and I don't think that video
to put pressure
ever
on
existed. Ever existed.
Yeah, exactly. I think you're correct, and I think that's exactly the reason why. I think they would use it to put pressure on the defense and on Karen Read to admit, take a plea, whatever.
I think they wanted her to plea out.
Yeah.
And thank goodness Yannetti got that tip. Mm-hmm. Otherwise, she would have pled out. Okay. Another thing that's troubling along the same lines. Mm-hmm. Huge piece of lore in this case, and there's a piece of gossip out there reported by Turtle Boy. I have not obviously verified it yet, nor has he, but he tweeted that the foreman of the jury is somebody who was a guilty voter on the manslaughter charge, and the foreman of the jury was hung up on the evidence of microscopic pieces of taillight in John O'Keefe's shirt.
Okay, right.
Which is something we heard Lally say in the trial again and again. The ARCA guy, he said, would your opinion change if you knew there were microscopic pieces of taillight in John O'Keefe's shirt?
Right. And did he say that also in opening arguments? That would be, yes.
Guess what?
That was never presented in evidence.
There's no witness that testified to microscopic pieces of taillight in John O'Keefe's shirt. Mm-hmm. There is no report. There is no evidence exhibit that testifies to this. In fact, there was a technician, an analyst, who examined the small pieces of glass and says they were provided separately from his clothing, and that's not the same as them being in his clothing. So the fact that Lally keeps asserting that there were microscopic pieces of taillight in John O'Keefe's shirt, that is a prosecution assertion that is not in evidence in this trial.
Yes.
That is fucking wild to me. This is one of these things that I believe if Alan Jackson had been able to make the full day or whatever closing argument he wanted to.
He would have pointed out that never came into evidence.
It never came into evidence. Yet, Lally kept putting it in front of the jury as a fact by building it into questions that he asked witnesses. Would it change your mind, dog bite expert, if you knew that there were microscopic pieces of taillight? Would it change your mind, dog bite expert, if you knew that there was no dog DNA found? Like, he would ask them questions about things that were either unimportant or untrue as hypotheticals, because you're allowed to ask hypotheticals. Yeah. And he would plant the idea in the jury's mind that there was evidence, but there was no evidence, and they didn't have transcripts, so they weren't able to look back and say, like, oh, who said that? Who didn't say that?
It's funny to me, though, that Jackson and the defense team did not raise that, because if they were
How would they raise it?
Well, if they were given discovery and they said that, they would know that report doesn't exist.
Who would they ask that to?
How would they what?
Who would they ask that to? Like, there was what witness would they
Your
ask
Honor,
that to?
sidebar.
There were
many
sidebars.
The state has not presented us with this report.
Right.
Are they holding it back? Does it exist? You know, that's the thing.
That could have come up in a sidebar. Yeah, that could have come up, and she could have said, I'll allow it. We don't know.
It's a hypothetical. But okay, then I would argue that would have been another appealable error. But it could be a couple of things. One could be that report exists, and they messed this up by not putting it in evidence. Right. Because those sometimes they don't have, like, the witness identify the defendant. Like, the little stupid things that actually mean a lot sometimes happen. I don't know if, like, you've been on trial for a month and you keep referring to this and you don't put it into evidence. But you're right. That's very interesting.
It's wild. All right. So finally, before we wrap up, I just want to talk about it very briefly, not in detail. The Alec Baldwin case, dismissed with prejudice this weekend. Do you
Same thing. That was in my head about the report when yeah.
So I just want to explain to you very briefly what happened without any detail, names, etc. In case listeners haven't quite grasped it and just know that it was dismissed. Here's essentially what happened. There was a previous trial of the armorer on the set in the case, and she was convicted, right? So after her conviction, one of the things they were looking for in the case was they were looking for the source of the ammunition that killed this photographer, right? They were looking for the original pile of bullets or whatever. After her conviction, a citizen connected, to the armorer, brought bullets to the police station or whatever and handed them in. And the investigators in the case, a technician in the case, met with a cop and the prosecutor, and they willfully decided to not put this evidence in the Alec Baldwin file. Right.
It's important to say what this ammunition it may or may not have actually been relevant, but that does not matter. This wasn't this bullet was. That is not the point at all.
I can't even
we know about Brady violations.
Talk about that because it sounds like it was a Brady violation because it was potentially exculpatory.
But potentially, but explicitly, willfully.
Yes.
It wasn't an oversight.
Correct. So what happened in the trial was when this came out, all of a sudden they had to have one of those hearings within the trial. And they put the fucking prosecutor.
No, the prosecutor put herself in the stand to testify. Yes.
And it did not go well.
Oh, no.
And all sorts of stuff came out. And essentially, there was a special prosecutor assigned to the case who quit after the lunch break because she was saying, we need to dismiss these charges. The prosecutor did not agree with her, so she fucking quit. She's like, I'm fucking out of here.
Yeah.
I'm sure she was
why. Yeah.
I'm sure she's like, I'm not going to ruin my career over this bullshit.
No. And I think she sent an email, perhaps to the New York Times. I'm trying to remember where I read it, but basically said, the prosecution has a duty not only to assure justice, but a duty to the defendant's rights.
Correct.
Basically, again, saying what we would say is the right thing. And so if that means we messed this up, we got to, we got to pull back.
I would tell people, by the way, Alec Baldwin's behavior
they say
during
it's
this
the cover up. Because again, this evidence, just kind of looking at it from afar,
who knows
probably doesn't do a lot.
Who knows what it means? I don't fucking know.
Yeah.
I actually know
they
very
were building
little.
their defense on not on whether he handled the gun the right way. They were going to build it on how the ammunition got to the set.
Correct.
Right? That was sort of where they were going. So anything about the bullets, I think, was going to fit into that narrative that they were going to try to make.
Right.
So this is important. Whether any of it's actually exculpatory, we'll never know. It doesn't matter. But it is just a fascinating case and a great learning moment for the public who have not been really following these kinds of issues like we have in the true crime space for the past decade to realize, hey, these little things are important. The defendant's rights are important. And
if you have money, your rights are stood up for.
Yeah. And and you love it on TV when the cop or the prosecutor goes all rogue because the system doesn't work and we're going to break the rules to get justice. And this is what happens in real life. You can't do it.
Well, you can't do it to a rich person. You can't.
You can't do it exactly.
Especially, by the way, I just want to say one last thing.
It isn't that rich people there's a different brand of justice for them. It's just they're the ones that can afford the lawyers that will do the work and find it.
Exactly.
Yeah.
So one thing that I want to point out about the trial, I was watching it in and out when people would say on Twitter, you got to turn in right now and see what's going on. A, Alec Baldwin's lawyer was really a character. B, Alec Baldwin's behavior during this trial was just so fucking weird. The faces he was making, at some point you could tell he wanted to have outbursts in the courtroom. He would put his hand over his mouth. He would turn around and talk to Ilaria, and she would do this with her
Silencio.
finger to get him to turn back around. Turn around, Alec. At one point, he fucking stood up and walked out of the courtroom.
To get a drink of water?
No, he says coffee in the middle of the prosecutor talking about him.
It's in a fucking movie.
She's talking about him lying about something. He literally stands up and walks away from his table, and you should see his lawyer's face when he does it. It's wild. It was a wild trial, but ultimately, I think because of the prosecution's conduct, it worked out the way it should have. Fuck all these people. And by the way, I'm not a fan of Alec Baldwin's personally. By the way, the other thing I learned on the trial was that at least one other actor, maybe more, also had live ammunition in their guns.
Yeah.
It seems like an accident that
it
could have happened to somebody else. And so whatever you might personally think about Alec Baldwin, the human being, this does seem like a really horrible tragedy that was the result of a string of things that people did that he necessarily didn't have control over. So whatever. Anyway, that's where I want to leave it with the Readathon this weekend. And obviously there's more to come. We have a whole week ahead of us, during which I'm sure lots of stuff is going to happen, because it always does. And I'm doing my best to try to line up a special guest for the Readathon. We'll see if that comes together. So Kevin.
Yes.
Thanks so much for sitting down with me to chat. I really appreciate it.
Partners in Crime Media.